Welcome, everyone, to today's conversation on where we're at with immigration policy now that we are 100 days into the new Biden administration. And thank you to our co-sponsors, the Friends Meeting of San Antonio and the Friends Meeting of Fort Worth, for helping us host this conversation. Please make sure that you are on mute to prevent background noise and to prevent the background screen from skipping off of the PowerPoint presentation. We will be recording this conversation and it will be available later for public viewing. Our focus today is going to be on executive action. So we will not be discussing in detail immigration issues that are solely in the purview of Congress or the courts. Each of the 5 topics we'll be discussing today, we will review briefly for about 5 minutes. We'll present you with some advocacy opportunities, and then we will leave some time for question and answers, approximately about 10 minutes on that topic. Please save your questions unrelated to that topic for the end of the presentation. We're also saving a few minutes at the end for any additional matters we weren't able to get to. I won't be able to monitor the chat regularly, so if you do have questions, please make a note of those and ask them during the Q&A. So the topics for today's discussion will be border policy, detention, asylum, enforcement, so interior enforcement, as well as several matters related to the immigration court system and affirmative benefits. You can see on the left-hand side of your screen a list of the different community sign-on advocacy letters that the Migrant Center has put together based on our experience working with people on the ground and the issues that we've seen are very problematic for them as they work their way through the immigration system. I will be providing links to those in the chat as we go forward during the Q&A section. I should also note that this PowerPoint will be available separately from the recording so that you can get access to all of the hyperlinks that are present in this recording. Okay, so first off, border policy. The Migration Protection Protocol, or often referred to as the Remain in Mexico program, was officially ended on January 20th at the very beginning of the Biden administration. However, it wasn't until about a month and a half later, or rather a month later, on February 19th, when DHS started processing individuals into the US who had been placed in MPP. So around this time, there were close to 30,000 active MPP cases, and about 43,000 cases had been already completed. 30,000 of those cases had resulted in removal orders in absentia. So that means individuals who had not shown up to court and received an order for deportation for not showing up. This is really important to note because for individuals in the United States, the rate at which they attend every court hearing is close to 90%. And in some cases, for example, where someone has representation or they're in the case management program that we'll be discussing later, that can even be higher, close to almost 100%. So the high rate of in absentia orders with the MPP cases begs the question of why. There's a couple of reasons. One is access to US immigration attorneys in Mexico is almost impossible. The other is the extreme violence that has basically forced people to not come to the border to present themselves for their hearings, which often require that they show up at 4 in the morning. The cartels and gangs have heavy presences along the border. And we talk to people fairly frequently who have encountered these problems. I had a conversation with someone just this week in detention who went to 2 of his court hearings, and on his way to his 3rd hearing, he was kidnapped by a cartel, received an in absentia order, and now has re-entered the country, but does not have an active case because of that prior deportation order. So there are about 4,000 people who have just this year kind of come across into the US because, without documents across the river because they haven't had another option. The current process is that individuals register through the UNHCR, United Nations High Commissioner for Refugees. CBP estimates it's processing about 30 300 people a day, and is testing everyone and making sure that they're negative for COVID-19 before admitting them into the country. Most individuals are placed on some form of alternative to detention. That does include ankle monitors in some cases. And for those of you who are here in the San Antonio area, we had one of the 3 family detention centers, Carnes, recently be converted to a processing staging facility for these cases. So the numbers are fairly low there. People are getting processed out, and by and large in less than 24 hours. Currently, there are 17 people at Carnes. So for NPP cases that are currently open, things are processing, albeit slowly. Unfortunately, there hasn't really been any discussion out of the administration about what to do for those who have in absentia orders or maybe lost their case because they weren't able to work with an immigration attorney. Data shows that your chances of winning asylum go up from about 10% to about 50% if you're represented. So there really is a difference between having an advocate helping you in the process. So what the most recent data that I've seen is that about 4,000 people have been processed into the US and put into what we call 240 removal proceedings. Those are straight up immigration court proceedings, as opposed to having to go through a credible fear or reasonable fear screening interview first. And there's an additional about 3,000 people who were processed in under special circumstances. So the administration has been processing people based on how long they've been waiting, longest waiting in first, with the exception of individuals who are particularly vulnerable. So we've called on the administration, along with other organizations, to admit individuals who have in absentia orders and get those rescinded when those orders have been a result of the program itself. Initiate a thorough review of all the removal orders in the MPP program, and agree to reopen these cases. So DHS, the sort of government council, can work with respondents council to do this, because one of the problems that we're coming across, for example, with the individual I spoke with earlier this week, his in absentia order was in the spring of last year. And there's a time limit on when you can apply to get your case reopened, which he's passed. So the only way of getting it reopened right now is to get DHS basically to agree and to present a joint motion to the court. The Biden administration has kept their promise to end the prompt asylum claim review and humanitarian asylum review process. This is the process where individuals went through that initial screening interview in CBP custody. Often they didn't have time to consult with an attorney or otherwise get any information on the legal process in the US. And 74% of asylum seekers outside of this process passed their interview, but only about 19 to 29% in this process were passing. So we're clearly statistically looking at this problems between those two processes, not really giving people the same fair shot. And that was ended by executive order on February 2nd. The asylum cooperative agreements were also ended on February 6th. Those are the agreements where we were sending individuals to Guatemala, El Salvador, and Honduras to process their asylum claims there. One congressional investigation found that nobody returned to Guatemala had received asylum. So we're happy to see that program has been ended. On the flip side, we are still deporting people or expelling under Title 42. And that's the Centers for Disease Control order that basically was implemented through CBP in Operation Capio, that's saying when an individual is coming from a country with an infectious disease, which is basically every country right now, they can't come. And we've seen a huge number of people being returned. I think we're over 500,000 right now under this program. The January 21st CDC order requiring a negative COVID test for individuals coming into the US is relevant because basically this is an order that says, well, if you're flying into the US, you have a tourist visa to come, or we have an agreement and with a country where you don't need a visa, you have to have that negative test, but you can still come. Whereas we do not apply the same policy at the border, right? So we're not being entirely fair, right? It's a bit of a hypocritical system. The only exception to this Title 42 expulsion policy that we have right now is for unaccompanied migrant children. And as of April 19th, there were approximately 22,000 migrant children in federal custody. Now, the administration has said that they will end family separation, and on January 26th, the Acting Attorney General did issue a memo rescinding zero tolerance policy under which the Trump administration had been processing for illegal entry and illegal reentry parents of children and separating the children from their parents during those criminal proceedings. And while that's great that that policy has been rescinded, there's actually been no change in the law so far. So we are calling on the administration to basically set up a policy where they're not going to be applying, at least for individuals seeking asylum who under international law have the right to do so, whether they cross at a bridge or across the river, to basically not put across the board, whether they're coming with children or not, those individuals in criminal prosecutions. So we have seen a huge increase in these immigration prosecutions, and by one statistic, the increase was over 57%. And this is, there's some concerns it's taking away resources from individuals who have, basically the need to look at like drug trafficking, human trafficking cases, and other sort of more serious criminal issues. Families that were separated and still by and large remain separated, there hasn't been yet any policy on granting humanitarian visas for those families who are abroad. One of my former clients relocated to Belgium because she couldn't stay in her home country after she'd been deported, and there's no way for her to come back and be with her 10-year-old daughter in California right now. So there's still really a big problem there that we're waiting on to see if the administration will address hopefully soon. And I encourage all of you to, write letters to the administration, talk to members of Congress, and advocate around any of these issues that you feel are particularly compelling. The good news on the border wall front is we did get immediately an executive order halting construction, preventing the funds being transferred from the Department of Defense into border wall construction, and also redirecting the $1 billion that had already been reallocated for construction this year. We are still waiting to see if the administration is going to take any actions on improving accountability and conditions at CBP holding facilities. We still see people that are being detained outside of the legal time limits, where there's still a real problem with access to counsel in these facilities. And then lastly, we're calling on the administration to not prosecute or otherwise target aid workers who are providing humanitarian systems, such as placing water barrels in the desert in Arizona and other places. So we have a sign-on letter that I will share with you here in just a second that's basically calling on the administration to process asylum cases at the border, go ahead and test them, quarantine if necessary, make sure that we're being safe. But there's, where an individual is tested negative, there's no reason that our country can't process those asylum claims. And so we're asking the administration to do that. I'm going to stop here and see if anyone has any questions on any of the topics that we've discussed so far.
How do you want people to let you know that they've got questions? Is that a matter of?
Just go ahead and ask.
All right. Because they also have the option of raising their hand by clicking reactions and raising their hand. But then they got to remember to lower it.
Yeah, I cannot, as I mentioned at the beginning, for those of you who may be tuning in late, I don't have the ability to be monitoring the chat or any of the other functions here. So if you have a question, please do say so during the question answer period. I also will have our email provided at the end of the presentation if there's anything that you wanted to follow up with offline. And I'm going to just take a moment here to quickly share that sign on with folks. But if folks have questions on any of these issues, please let me know. Okay, I shared that link for folks who want to sign the letter. We will be submitting them tomorrow, which I believe is the official mark of the 100 days. So if you do want to get your signature on or share it with any of your colleagues or friends, just make sure that folks know that those are going to be submitted tomorrow. Probably around, I think we can probably take signatures until about 3 p.m. tomorrow. Okay, so I'm going to move on to our next topic, which is detention policy. So at the end of February, there were just under 14,000 people in detention. That number's hovered around there for the last several months. And about half of those individuals have pending court cases. We're still seeing problems with COVID-19 at the detention facilities. We've had close to 10,000 people contract COVID in immigration custody. We've had at least 8 detainees die from COVID complications. I was just on a call earlier today, and there's an outbreak right now at the Livingston Detention Center. They're having problems contacting counsel because they're preventing them from having access to phones and otherwise get access to visitation rooms. And then, concerningly, individuals who have to go to the doctor to pick up their meds. So, individual who might need a painkiller for a back injury or something of that nature is being told to wait in the same room with people who've tested positive for COVID-19. So unfortunately, we would expect and hope that the government would have figured out how to maintain proper, safe COVID policies within detention, but that hasn't seemed to be true in some situations. So, we're still very, very concerned and certainly want ICE to review these cases as soon as all of the cases, right, as soon as possible. We've called, along with other organizations on the administration, to conduct a comprehensive review to make sure that nobody's being detained who doesn't have a real need to be in detention. We have fortunately seen a number of releases for individuals who had been kind of stuck at the facility and weren't being released recently. So, we have seen that some of these cases are being reviewed. Some of the folks who have, risk factors have been released, but we still do get calls fairly frequently with people who have, problems like hypertension or asthma that puts them at risk. On February 4th, the UN Human Rights Council called on the Biden administration to end private detention and recognize that the administration on January 26th had decided to stop for-profit companies running federal prisons, but that this really should, for the same reasons, be expanded to immigration detention facilities. President Biden had previously stated that he was in favor of moving away from private control of immigration detention, but we haven't really seen anything play out yet in that regard. And one of our sign-ons is to kind of address that issue and make sure that the administration knows that people are still following that and care about that. The last family at the Berks residential facility was released. So there's still an open contract at Berks. Administration could go back to detaining families there. But for practical purposes, the facility has been closed for family detention. And with Carnes being transferred to a processing center, we're down to Dilley as being the only family detention center. So that's positive. And then as I mentioned earlier, we are seeing more individuals getting released, and that's a result of several different things that the government has done. On January 20th, a new list of enforcement priorities came out to focus on people with criminal history, and those were updated on February 18th. And then on March 5th, the administration created a case review process. And so this is really, really important. It's one of the things that we have been calling for a while. It creates another level of kind of accountability in decision making and gives us a recourse to what's effectively an appeal process, first with the field office and then with headquarters. And so that's really helped, I think, in some cases. I do also know that some attorneys have had some issues with that process, and found that it hasn't really resulted in positive review for their clients. Another issue that we had been following in the last couple years, former President Trump had created this information sharing program between the Office of Refugee Resettlement and ICE. So when somebody had applied to sponsor a child, and then if that individual was not in the country lawfully, their information was getting sent to ICE, and ICE would, in many cases, went and picked them up and deported them. So that had a chilling effect on families wanting to come forward and sponsor the unaccompanied youth. That, as of March 11th, has been suspended. And so hopefully now, there won't be any sort of fear in stepping forward for that family reunification process. Another issue that we've been following, and that's still pending, there's a BIA decision. So the Board of Immigration Appeals basically has said that to be released from detention, you have to have community ties. So typically to be released from detention, you have to have proven who you are. You have to prove that you have a stable place to live. And you have to prove that you're not a danger to the community and you're not a flight risk. And for years, it's always been considered a positive factor if you have community ties. The idea is if you have family and friends in the US, you're going to want to legalize your status, you're more likely to go to court. Unfortunately, under the previous administration, the Board of Immigration Appeals came out with this decision that if you do not have family ties, so if you're an asylum seeker, for example, from somewhere in Africa who has no community ties, then you are a flight risk by nature, right? So instead of just saying community ties strengthen your case and make it more likely you go to court, now the court system is saying, well, no, if you have no community ties, then you are, sort of per se, categorically a flight risk. So we work with a lot of low-income individuals, many of whom who are relocating to an immigrant shelter and don't have, family or contacts in the U.S. And so I've had several cases of individuals who have been denied release by the judge based on this decision. And luckily now, under the sort of the new administration, we've been able to go back to ICE and get them to redetermine their cases. And I've had two clients recently released, one from Cameroon and one from Angola, who had previously been denied by the judge under this rule. But really what we need to see here, is the Biden administration change that rule. So the Attorney General has authority to certify a case to themselves to review if they think there's been a misapplication of the law by the Board of Immigration Appeals. And the Trump administration uses authority very frequently. And this particular case would, I think, be ripe for consideration by the Attorney General. So hopefully we'll see some movement on this issue because basically, people who don't have family are being detained for no other reason. And we also want the administration to restart the case management program. That's the program that was piloted under the Obama administration to basically set up a caseworker for people who don't have attorneys to help them know when their court hearing is coming up, how to change their address, all the basic things and questions that they may have to move forward with their process. And then on U visas, so U visas are humanitarian visas that are granted to individuals who have helped law enforcement and investigate or prosecute a crime here in the US. On March 18th, ICE agreed to not deport anyone who had an application pending. So after 2 years, one of our clients was able to be released because of this. ICE is no longer going to deny stay requests or oppose continuances for people who are in the U visa process. This is super important because the administration or rather we could say Congress, basically our law says that only 10,000 of these visas can be given a year. So there's a huge backlog. And we have people who've been waiting since 2016 and before for the government to process their petitions. Now, they are supposed to get those cases reviewed, and if there's not a visa available, then they'd be granted deferred action with a work permit while they wait for a visa to become available. But that process itself has become incredibly slow. So, we were really trying to get that expedited for our client who was in detention. And even with ICE's assistance, USCIS was just sitting on it and they just weren't responding. So that's one place where the administration can get things moving. AILA, the American Immigration Lawyers Association, recommends hiring 60 to 80 more adjudicators for the U visa program. And then also the administration can parole from abroad those who have U petitions pending. So the U visa can be granted as a visa for individuals who are outside of the US, who obviously were previously here and helped law enforcement here investigate or prosecute a crime. And it can be granted to people who are still in the US. So the people who are still in the US, of course, are here with their families. They're able to support their kids, but there are individuals who in the last several years have been deported under the Trump administration, even though their U petition was pending. And we would like those individuals to be able to be paroled back in. Okay, so before we move on to asylum policy, here's our list of community sign-on letters, and I'll go ahead and put the direct link in our chat. As I mentioned, we want to end for-profit companies running these detention facilities. There's a lot of indication this results in cutting corners, really poor quality food, lack of medical care and other issues that come up. So that is one action that the administration can take. It will take some time, just in the sense that there are contracts that would probably have to run out their course. But there's no reason we need to be re-signing contracts with private companies. We also have been calling on ICE to give a written explanation for why they deny release requests. So even though we're getting a second review or a third, in some cases, third review of denials, and we have seen some movement and change and getting folks out, we're still not being given a reason, right? We get a paper that simply says, we decided to release or we decided not to release. We've looked at your case. That's all it says. There's another form that will sometimes come out that has a little checkbox, and it will say, we think you're a flight risk, but they won't give any explanation, right? And so this is really a big issue in terms of transparency and our ability as the community to hold our government accountable for the decisions they're making. The next is problems. We see a lot of problems with the ability to access evidence from inside detention. So detention cases typically have a higher rate of denial, and I do believe that one of those reasons is because it's very difficult to get evidence. In order to call out of a detention center, the person has to press 1 to accept the call, and that message explaining that is only available in certain languages. So I had a client who had to wait for a month before he could call his sister because she didn't know, when he called, she didn't know that it was him, didn't know how to accept the call. And then he met someone who eventually left the detention facility, called the normal phone line and explained it to her. And after that, he was able to start getting the evidence, but it slowed down his process, right? And then The other thing is there's no access to the internet. There's access to like very specific documents like the State Department Human Rights Report, but the individual is not able to really do their own research. And so this really affects specifically pro se respondents, those who don't have the means to hire counsel. The last thing that we're calling for is to establish an attorney visitation room quota. This is something that can be put into any contract that the administration has, but ultimately we hope that Congress will make sure it's a part of any legislation as well. So, at the South Texas Detention Complex where we work, it's a facility that can hold 1,900 individuals, and there are only 4 attorney visitation rooms. Currently, there's effectively 1 because they're only allowing 1 attorney in at a time. So 1 attorney comes, they can meet with 10 people, they could take 6 hours, and then you get to start your visits, right? So that's a real detriment in terms of encouraging attorneys to take these cases. Fortunately, now we just recently, about a month and a half ago, got access to televideo meetings, and that has really hugely improved the situation. So we're now able to meet with people confidentially, 2 people a day. And for the most part, that system has been working pretty well, but it is one of the only detention centers in the state of Texas that has that capacity. So, it's good as a trial run, but it really is something that needs to be established more broadly. And then we have here a list of 3 different pieces of legislation that are moving through Congress that that our organization supports. So we'd encourage you to look at those, encourage the Biden administration to support them, and your members of Congress. So I'm going to stop share for just a moment so I can send you over the link to those sign-on letters and open it up for questions if anyone has questions about detention policy. I should mention that for those of you who are on our listserv, our email announcement for this event also has links to the sign-on letters, as well as to our podcast series about these different immigration topics that we did during Dream Week. And so there's some more of a background on what was happening under the Trump administration at that point, if you want to dive deeper into any of these issues. Leave it up. Give people a few more seconds if anyone has any questions, or we will keep moving. Okay, asylum policy. So good news on the travel ban. Immediately on January 20th, Biden signed a proclamation revoking the various travel bans that the Trump administration had put into place, also known as the Africa ban or the refugee ban or the Muslim ban, as the countries that had been prohibited from having folks come to the US were Muslim majority countries. On the refugee admission program and admissions, so under the Obama administration, we were at 110,000 per year in terms of the number that we would be admitting, resettling individuals who had been determined to be refugees from abroad. And that slowly decreased, well, drastically decreased, but every year decreased, down to, at the end of the Trump administration, to 15,000 people. Interestingly, that's the cap, right? So as of March 31st, only about 2,000 refugees had been resettled in the US. And this is in comparison to 26 million refugees worldwide. The Biden had promised to increase the cap up to 125,000. Some of you probably heard that on April 16th, he issued a refugee determination, basically keeping the cap at the same level as the Trump administration of 15,000 for the rest of the fiscal year. There was a huge outcry by advocates and members of Congress on this, and in an example of how your advocacy can make a difference. Basically within 24 hours, the administration turned around and said, "Wait, don't get upset, guys. We'll be issuing a new determination on May 15th. This was just temporary while we figure things out." The administration had formally reported to Congress in February that the cap would be raised to 62,500 for the rest of this fiscal year. So we're probably going to see something between there. I don't know if we'll get up to the 500,000 for the last 6 months of the year, but of the fiscal year. But I would be very surprised if we did not see it increase from the 15,000. Again, keeping in mind that's the cap. The actual number of people resettled through the program is entirely dependent on how well these programs are functioning at the various embassies and consulates around the world. So related to this, on February 4th, the administration issued an executive order trying to improve our refugee admission program. It's a fairly long order, but a couple of points that I found particularly encouraging. One is that we are going to have a focus on resettling folks who are at risk related to their gender expression, or their sexual orientation. That the agencies should consider as spouses those who are in committed life partnerships but who cannot legally marry because of restrictive laws in their country. And then we're also going to be looking at whether the US government should expand the special immigrant visa program for individuals who have assisted the United States government in conflict areas. So basically, during the Iraq War, a lot of individuals worked as interpreters and otherwise helped the US Armed Forces. And then as a result of that, faced high levels of persecution in their country. So this program was developed specifically to help a certain sort of population in a certain conflict doing certain things. And Biden is asking the administration to study whether this should be expanded to include individuals, in any conflict around the world where this may, as a result of helping the US government, they may be at risk. So, these are areas where we as a community can encourage the administration in that process of evaluating their cases to, come to the correct decision, right? And sort of be part of that conversation. The other interesting part of this executive order is that Biden's directed the administration to prepare a report on climate change and its impact on migration. So there's going to be a more in-depth look at climate refugees, which is something that hasn't really been addressed in any real comprehensive way to speak of, at least not at the national level. Okay, so on asylum law, we've seen a lot of changes in the last few years, mostly for the bad. And we're just starting to see things flip back to normal. So the Biden signed on February 2nd an executive order that, again, is calling on the administration to study our interpretation of the law with regards to gender and gang violence cases. Some of you may recall that in a couple years ago, and then again in January of this year, the Attorney General issued a decision in matter of AB. And that basically said that victims of domestic violence cannot be protected in the United States, and then had a little footnote, in dicta, basically said, well, this would apply to gang violence too. As anyone who practices immigration law knows, each case is looked at or by law on its merits. But what this has done is it's resulted in judges being feeling like their hands are tied and being very hesitant to grant protection in these cases. So the case of the separated mom who's now relocated to Belgium, this is why her case had been denied, was exactly because of this order. And it's affected hundreds of, if not thousands of women in the last couple of years, primarily women, it's not exclusively. And the Biden is also looking in this executive order at the definition of particular social group. So this is one of the most complicated areas of asylum law because, what does particular social group mean, right? It's considered to be a group that you're part of that you either cannot leave, or you should not be asked to leave because it's fundamental to your identity. But it has to be a group that can be defined and is recognized in your society. So that's the overarching framework. But when it comes to practice, it can get a little complicated on what qualifies and what doesn't. It's not clear if he's going to be reversing the Attorney General decisions, if he's going to be issuing new notices of proposed rulemaking, pushing for legislative change, or otherwise not pursuing litigation on these issues. Now, he did say that he would go back to the original interpretation of a political opinion that had been changed in one of the notices of proposed rulemaking from last year that's currently on hold, but hasn't, to my knowledge, since taking office, followed up on that. He also has been silent on the change in the definition of persecution and whether or not a family can constitute a particular social group, the standard for unwilling and unable to protect. So the idea is that an individual can only get protection in the United States if they show that their government, so their police, is unable or unwilling to protect them. And that standard has been changed to complete helplessness or condoning the action. It just like on a plain language reading of, of the dictionary, is a higher standard, right? The previous administration had also put out a decision on duress as no longer being an exception to the material support bar. So if you have a mom who's forced to feed a member of the gang under threat that her son's going to be shot, she would not be able to get asylum because she provided support to that gang, and duress is not an exception. So we have a podcast on that. We also did a public comment looking and analyzing sort of the persecution political opinion issues that folks can read up more on those. And then we also have several resources on, what is a particular social group, looking at gang violence and gender violence, as well as family. Moving on to UAC. So a UAC is an unaccompanied alien child. These unaccompanied minors under a 2019 policy had been taken out of the unaccompanied minor category, and if they had turned 18 at the time their application had been filed, or if a guardian had become available. So previously the rule was once a UAC, always a UAC, right? However you came into the US is how you were processed through the immigration system. And the benefit of being considered a UAC is that you are able to have an interview with an asylum officer and win your case with the asylum officer in a sit-down conversation type non-adversarial setting. In the normal process, right, people go before a judge. They're in removal proceedings and they're cross-examined by a government lawyer. And so under the TVPRA, the Trafficking Victims Protection Reauthorization Act, it was determined that children really should be in a less adversarial setting because it would be easier for them to explain their claim. And now, as of March 4th, we've gone back to that policy. Right, so now children, regardless of if later they age out or or come of age, I guess would be the better term, or if they have a family member that's now providing support for them, they would still be able to go through that non-adversarial process. The Central Minors, American Minors program was reinitiated as well on March 10th. Department of State announced that it's going to be beginning again to process children for reunification with their family who's it has to be a parent, but with a parent who's legally present in the United States. And that program is specifically operating in El Salvador, Guatemala, and Honduras. So hopefully we'll start seeing these kids be able to come over directly, right, through the legal process, meaning they can get a visa and their passport and take a flight and don't have to make the dangerous journey through Central America and Mexico. And then the last point on asylum policy that's important to mention is work permits. There is a Trump era rule that's currently in place for most people. The exception is individuals who are members of ASAP or CASA because they have litigation pending. But basically, Trump said that you can't just wait 6 months, to get your work permit. Now you have to wait a year. And that's from the time, not from the time you enter the country. It's from the time that you submitted your asylum application. If the court has not processed your case within 1 year, you can get a work permit. But if the court has, it's taken 6 months and you need to work, well, you're out of luck. The regulations basically previously asked USCIS to have a 30-day processing time for those requests. That was also eliminated. Under the new rule, if you are not applying within 1 year, then you can't get a work permit. If your case is on appeal, that's also questionable. Some of those cases are running into difficulties. So we're working with several people whose application has not finally been decided because the case is on appeal, right? It's getting reviewed by a panel member of the Board of Immigration Appeals. It's going to be, I'm doing several of these cases right now, but it's going to be, according to what I've heard, probably pretty difficult to get USCIS to approve their work authorization. And that really benefits nobody, right? Like, these are folks who need to be able to support themselves and not become a burden to others in the community, and who typically want to work, right? They want to be able to be independent, stand on their own two feet. So I'm going to stop share screen right here and see if anybody has any questions about asylum policy.
It's really nice to have all of the details, but I think that I'm finding myself, it's hard to create a question out of that.
No worries. And I know it's a lot of information to go over pretty quickly. And I know I'm talking maybe a little bit quick too. So it can make it hard to absorb everything. But all of our contact information is on the last slide. And I will make sure that we get the PowerPoint slides out to folks as well with all those resources.
It's just nice to get the detailed information because this is the only place we can get it. We can't get it in the newspapers. Yeah.
Yeah, and a lot's really happened, in the last 3 months, with, of course, the caveat that a lot also still remains to be done. And really, we definitely want to acknowledge that the administration has moved forward in some very positive ways with making our system more humane and fair, but not, becoming lax either in making sure that the administration continues to stay, moving forward in the right direction. I do understand that Biden will be speaking to Congress today and talking about immigration. So I don't know what time that's going to be. I'm sure there'll be some news reports on it, but folks might want to tune in on that too, just to get a general feel for the direction that the administration feels like they're heading in. And in my experience, I've seen sometimes what's out in the press, the big ticket items, that either coming from the administration or that are coming from some, emergency that's happening that day, like when we had family separation. Sometimes, those issues, while important, sort of crowd out other issues that have real impacts on people's lives that just don't get sort of the attention or media coverage, or attention by the administration in Congress. So, we want to make sure that at the migrant center that we're letting people know like what we're seeing on the ground, so that there's more sort of knowledge around all the issues that are really impacting folks. And hopefully then that conversation can then move things along. I'm going to go ahead and
Biden is speaking at 8 Central Time tonight.
8 Central Time, perfect. Yeah, I had just seen that before this started, and I did not have a chance to look up any of the details. Okay, so let's move on to interior enforcement and judicial review. Some good news here. February 18th, in that enforcement priority memo that I had mentioned earlier, the administration is prohibiting collateral arrest during enforcement actions. And this is something that we've probably all heard about. I've seen it. For example, one of my clients from Austin, he lived in an apartment with several other guys. ICE came to pick up one of the other guys, and they picked him up too, right? And then it was several months trying to fight his way through to get out of detention. But that's, in theory, not going to be happening anymore. So that's great. And then yesterday, we got good news that DHS will be limiting courthouse arrests. So this was a really big problem that had started under the Trump administration. Not to say that this has never happened under any other president. There's always exceptions, and of course, if someone is a top priority for enforcement, they will be picked up at a courthouse. But what happened was the ICE was just like basically either going into the courthouses or just like posting up outside the courthouses. And so when immigrants went to take care of sometimes, small civil matters like paying a traffic ticket, they get picked up and put in deportation proceedings. And the other issue with this, of course, was that witnesses and victims were hesitant to go to court to testify. So it really undermined the ability of our court systems to reach correct verdicts in some of these cases. And so now the guidance is limiting those enforcement actions at the courthouses. We also got good news on the expansion of expedited removal. So expedited removal is basically the law that says if you're picked up anywhere within 14 days or and 100 miles of the border, you can be sent back without seeing a judge. And Trump had expanded that to the statutory maximum of any time within 2 years and anywhere in the US, with the burden on the individual to prove they've been here 2 years, right? And so that was ended by executive order on February 2nd. So we still do have expedited removal. There's still issues with people not having rights to see a judge, but it's not going to be something that is really going to be applied across the nation. It's just something that we're going to continue to see here at the border. And of course, folks who have asylum cases, they can apply to get out of that process by doing those credible fear or reasonable fear interviews. And then if they pass, they'll get scheduled to see a judge. Now, the detainer program and the 287G program are two programs that are really about executive authority, right? So the detainer is when ICE says to your local sheriff, it says, you have to keep this person for 48 hours. We're going to come pick them up. And many courts around the country said that's not legal. The sheriff or the city can't continue to detain someone after they've been granted bond and paid it or otherwise completed their sentence. So this is, but it is still something that does happen. And then what sort of the other way that we see something like this happen is through the 287G program, because what that does is it officially deputizes local law enforcement officers to act as immigration agents. And so then they have the authority to continue to detain someone as an immigration agent. And this has, the concerns here is that this is eroded community confidence in law enforcement, right? And has led, at least in some cases, to racial profiling. So those, I haven't heard anything, and I don't know, what the official position really is of the Biden administration, one way or the other on this. I suspect that this has been more or less on pause and sort of operating as normal. But I don't know if we'll see a real shift. Hopefully we will in the coming months on this. And then the quick note on sort of staffing and sort of internal agency relations. So recent announcement, I think it may have been yesterday or today, the ICE director is going to be Harris County Sheriff Ed Gonzalez. So that's Houston. He did end the 287G program there, but it was after a 3-year advocacy campaign. So the folks I was talking to today who are working down in Houston were saying they're not feeling optimistic about this appointment, in part because Harris County has the highest number of ICE arrests and detainers in the country. And also is one of the biggest cities in the country. So, you probably have to do a little deeper dive, but there's not a feel in the local community that Sheriff Gonzalez is particularly immigrant friendly or really even understands the ins and outs of how these enforcement processes work. And so there's I think some hesitation and concern about this appointment, despite the fact that he has done a few good things like important things like ending the 287G program. And then I'm sorry about this. I think there's a typo right here. But basically, on January 19th, just in sort of midnight rulemaking, so to speak, the Trump administration had struck a deal with the ICE union, giving the ICE union power to veto any presidential actions on enforcement priorities. And that deal basically had a month to run. And so right at the end of that, the Biden said, nope, we're not going through with this deal. We want to be able to enforce our own priorities without you all coming in and overturning us. And so that's good. And then the other issue, which I haven't heard anything from the administration on, but a court ruled on March 12th that ICE cannot destroy records about abuses in its facilities. And basically what happened was last year, the National Archives and Records Administration had approved ICE's plan to destroy these records without addressing serious public comments. And so that's why the court said, no, you can't do that. But it's not clear what the current administration's position is, right? So if they're gonna basically try to move forward and say, well, we'll give time for comments, but we're still gonna do this, or if they're just gonna sort of withdraw, and not this litigation and not continue with the destruction of these records. So yeah, so that's still a little bit pending in terms of the administration's stance on that. There's a whole number of court cases across the board on immigration issues that are in some stage of litigation. And the administration really has a choice to make on if they want to continue to prosecute these cases. So that's it. Even though these are court cases, there is still very much a role for advocacy in trying to get the administration to take a better stance on these issues. And there's at least one important example I'll be talking about in just a minute. So on judicial review, so we have seen an increase in the last few years of denials of asylum cases. Last year, 72% of asylum cases were denied. And there's a whole variety of reasons why this may be the case. A couple of things I want to really just highlight for you all today is that the immigration courts are not independent. I know some people on this call are probably well aware of that, but I think it's always worth emphasizing that, under our democracy, we establish a system of checks and balance between the executive, Congress, and the judicial. And now we're at a place where, or I should say we've always actually been at a place, but where the court system in the immigration context is not independent, it's part of the executive. And then we moved to this place where we are now, where the administration has come in and really kind of tightened the court's independence and really sort of clamped down on due process. And there's been a whole variety of things that have happened. So for example, the previous administration instituted a case completion quota, saying that 700 cases per year have to be completed. And, for some courts, that's not a problem, right? To be honest, in detention courts, there's a lot of people who are just going to do deportation orders. They're not going to do full cases. And meeting that number is not going to be a problem. However, non-detained dockets, this is a problem. And I will say, even on the detained dockets, I have noticed a significant increase in the judges trying to move cases quickly. So previously, a judge would assign an asylum case for their morning docket and then another one for their afternoon docket, so about 3 hours per case. And you really do need about 3 hours per case. I have had cases that have lasted several days. And now the judges, or I should say about a year, maybe 2 years ago, the judges were starting to try to do 2 cases in the morning. I've even, more recently seen them try to do 3 cases in the morning. And so it's like this becoming this rapid sort of rocket docket. The other thing is there was like a no dark courtroom policy, which basically meant that the courtrooms always had to have active cases going, which meant the judges were in camera, sitting in their rooms, reviewing the evidence and the documents a lot less. So that's just like one problem. The administration under Trump also had like limited the ability to terminate cases, administratively close them, grant continuances, and other sort of docket management tools that would allow the judges to focus on the priority cases and make sure that other cases that maybe need a little bit more time to process a U visa, can get that time. So we have been calling on, along with many other organizations, including the American Bar Association, for the immigration courts to become Article 1 under the US Constitution, independent courts. That is something that Congress has to do. But of course, Biden can encourage Congress to introduce and pass certain pieces of legislation. And so, that is like one of the top priorities in terms of what will have a broad impact on a lot of things across the board. Because right now, the immigration court system, how cases are and how the laws interpreted and applied to individuals, and then all these other logistical, due process issues that come up, is solely dependent on basically like one political appointee, the Attorney General, right, who's in charge of the court system. So, you have a shift in the political winds, and then the whole justice system turns around. And that just really doesn't make sense. We also would like the administration to conduct a review of the 1.3 million cases that are on the docket and remove those cases that don't need to be priority. So there were about 350,000 cases that had been administratively closed that the Trump administration threw back on to the court's docket, even though the court says everyone knows are super overwhelmed. And that's really unnecessary and not helpful to people. So I can just tell you from my experience, there are certain cases that need to move slowly, and there are other cases that need to move quickly. And I have a case, for example, it's been at the Board of Immigration Appeals for 2 years with no decision. I want that case to move, right? And it can't move because the court is getting tied up and stuck on all these other things that are not priorities. So there's, the way that the cases are managed really can't happen at a macro level. It really needs to happen with the individual judges who are looking at the individual case files. Because every case has a different way that it's going to need to be processed to really ensure due process and a fair hearing in court, right? Sometimes people need more time to get evidence. Other times people want to expedite their cases, right? So that's just one thing that does have a really broad impact that sometimes doesn't get a lot of media attention. But the last point I want to mention on judicial issues is the National Association of Immigration Judges Union has been prevented from engaging in collective bargaining. And Biden has traditionally been very in favor of supporting unions and workers, but so far has not spoken any about overturning this ruling. And so, that's another area where the administration can look into things. So I'll take a little break right now if folks have questions on anything here, and I'm going to send a link to the two advocacy letters that we have. The first is just a real general one about restoring justice through, the judge's ability to manage their dockets. That doesn't mean every judge is going to have, the right outcome in every case, right? But it does mean that people are going to get individualized attention and consideration of their particular circumstances. And then the other one is on language access. So basically, we want people to have the right to translation services as well as interpretation services. So right now there will be an interpreter in immigration court, but the individual is required to read and then English applications and then fill out those English applications in English and return them. And so this creates a language barrier for sure. Translating those forms will not be that time consuming or expensive. And then where people don't have representation or are indigent, having someone provide translation services, I think is a minimum necessity for ensuring due process. So it's one of those little issues that flies under the radar, but that can be a real problem for people. I've seen people get issued orders of deportation because they haven't turned in their application on time, and the judge will give them more time, and then they'll give them another continuance. But if the person is like struggling and trying to fill out their form, and then eventually the judge is just like, well, you're not giving it to me, so I'm going to order you deported. And it's just because they don't speak, read or write English.
So, Sarah, I had a question for you.
Yeah.
How does somebody become an immigration judge?
They do have to be a lawyer.
Okay.
And they basically apply. I could apply to be an immigration judge, which I would never want to do because I wouldn't want to deport people. And our laws, unfortunately, are just too restrictive to really, be able to be in that position and not deport people to danger. But what happens a lot of times is they end up being prosecutors. So the ICE has what's called the Office of Chief Counsel, which is where the government lawyers are hosted, and where they're headquarters. So we have the two main branches of ICE that we typically deal with are enforcement and removal operations, which are the deportation officers that process like release requests and pick up people in raids, and then OCC, Office of Chief Counsel. But so typically what happens is the people who apply for the jobs, they could be private practitioners, but they're typically going to be people who are prosecutors, because for them it's a step up, right? For them it's going to be increased income, increased independence on decision making, and they're already in the government, right? They get the government benefits. I think for private practitioners, we typically don't really kind of want to make that drastic of a career shift. But so one of the things, there was actually a great article out of San Francisco Chronicle, and I know I have some resources on this somewhere, but including a link to the article. There's been some real concerns that like the hiring process has been politicized under the Trump administration, right? That like certain questions that were just to kind of get a sense of how the judges were going to decide specific cases on specific issues were being asked. People who had been already hired by the Obama administration had their appointments were like being delayed for like a year or a year and a half. So they couldn't get on the bench. And then we've seen a lot of promotions, including to the Board of Immigration Appeals, of judges who have really low grant rates. There is a very large disparity between courts and between judges across the nation, which is also a problem. But yeah, typically, and then they work for the Department of Justice, right, which is the agency that hosts the Executive Office for Immigration Review. So their boss is going to be the Attorney General once they're judges, right? So I hope that answers your question a little bit.
Yeah. Just seems like a critical role. Seems like so much gets down to the judge and what they want to do.
Yeah, and I mean, they do go through some training. There's some concerns that they don't have like proper training. So in the sense, so like Jeff Sessions, when he was Attorney General at one point, he was basically saying, well, all those everyone's jumping into using asylum to just like go through these loopholes and just jump in through the country, and they're really just here to work, and the immigration lawyers are just helping them commit fraud, right? So he was, their boss was basically saying, you need to be suspicious of the immigration lawyers and trust the government lawyer more. I will say, when you're going before a judge who was a prosecutor previously, they're going to be thinking a lot about fraud. I mean, I think all the judges do, but especially ones that come from that background. And so, there's certain things that happen just because of where someone's from, like culturally, and because they don't know how to explain certain things. So like when we do prep, one of the things I tell people is like, our truth is really exact in the US. If you say, I take my kids to school every day, the judge is going to think you're lying because they don't have school on Sunday, right? So you're not taking them every day to school, and so there's like a lot of little things that can really trip people up, even though they're not intending to lie. And like, that's how they would tell their story naturally. So there's a little bit, like, in terms of our work as attorneys, there's a little bit of like cross-cultural communication that has to happen. And then education of the judges too. I mean, you want them to know all the law and you want them to interpret it all correctly, but they don't. I actually had a really good news. Day before yesterday, we won a case at the Board of Immigration Appeals. And I had a couple of people say, oh, well, you must just be thrilled. I said, well, yeah, I am. But I feel like you should have never lost in the first place, right? And interestingly, one of the judges on the panel, so we had you usually get one judge, and I always request 3, because then they're accountable to each other, right? They're kind of looking over each other's shoulder. And I feel like you have a better chance of getting approval if you get those 3 judges. One of them that was on the panel is a notoriously bad judge. And I don't know about the other 2. He might have just gotten overruled by the other 2. But I also wonder if the rhetoric and the language is shifting, and maybe there's some internal conversations that are happening and review that's happening that, they're not wanting to tell externally, right? They're trying to just doing it all sort of on their own. But yeah, I mean, the judges by and large, like, are, with some exceptions, but by and large, they're respectful. They'll try to work with you on stuff. I think generally they do want to get to the right conclusion, but I think sometimes they just don't get certain things, and it may seem obvious to somebody else. And so a lot of it is really about just how you tell the story in a way that's going to be understandable to them. Yeah.
I have a question. Can you hear me?
Yes. Go ahead, Tammy.
Thanks. So you were talking about asking the Biden administration to not review or to somehow take out of the list of pending cases those that are not at a risk, type of people. So what does that mean to those people who are in line for those immigration hearings? And I asked that because we had an ICE raid in our town, and so we have these people who are waiting here. We're coming up on 3 years. They're still waiting for immigration hearings. Does that mean they can have work permits, renewed every 2 years and they can keep going? Or for those who still don't have work permits, I mean, what's their future if they don't have immigration hearings?
Yeah, so I think you raise a really good point, which is we don't want the government to necessarily just make a decision on their own of what cases shouldn't go to court, right? Because the individual might have a completely different view on that. So if somebody's scheduled for a court hearing, let's say in 6 months, and the DHS ICE attorney says, I don't think this case is a priority, they actually, I mean, they don't really have the authority to take it off of the docket now that it's on the docket. That would be the judge. So they could write a motion to, administratively close the case. And then the immigrant would be able to, should be given 10 days to respond, right? So they would be able to say, well, no, actually, I really need my case to go forward, and here's why. So it really should be it shouldn't be the government has all the power. It really should be a conversation between the 2 parties, right? And with the judge ultimately deciding, and is really going to need to be an individual determination. So that's the first part of your question, I think. there's no way they could just say, okay, well, these were all administratively closed. Let's just administratively close them all again. I mean, I guess they could do that. And then people could make individual motions to not be administratively closed. I mean, that would be like the reverse way of doing it. But the second part of your question on work permits are always tied to some type of legal status or pending legal status. So if somebody has a court case that they haven't applied for anything, they're not going to be able to get a work permit. Unless, with the caveat, of course, that unless they were released on a certain, in a certain way that would allow them to. So if you're released on an order of supervision, or if you're released with an I-94 card, that would give you a pathway to get a work permit. But yeah, typically you're going to have an asylum application that's pending, or a cancellation and removal application that's pending, or an adjustment of status application that's pending, and then you can get a work permit based on that. So once that application is in, yes, you could keep on renewing it until your case is decided, whether that's going to be 2 years or 5 years down the road, barring some drastic change in the law. But yeah, it's typically that works. I mean, the idea here is that like people shouldn't be prejudiced because the court has a huge backlog, right? People need to be able to work, and if our justice system isn't going to decide their case one way or another, then like we shouldn't just basically force them to be unemployed. Hope that answers the question a little bit. Anything else, folks? We have one more topic for today, so I will go back to screen share. And then I think we should have a couple minutes at the end. If anything, for any other questions. Okay, so affirmative benefits. I know this is kind of a not very helpful title for those of you who are not immigration practitioners. But basically, this is everything that doesn't happen in court. So we saw legal immigration go down by 50% for a variety of reasons under the Trump administration. And we're starting to see some of this change, right? And the numbers haven't increased yet, but we're opening up avenues for people to come to the US again. So on February 24th, Biden signed a proclamation basically revoking the prohibition, Trump's ban on individuals coming on immigration visas, either employment-based or family-based immigration visas. To give you a little bit of terminology, immigration visas or immigrant visas are for people who are coming to live permanently in the US, right? So this is people who are coming with green cards. Well, they get the visa, then they come here, and then they get the card. But basically, these are immigrant visas are permanent. Non-immigrant visas were also blocked by Trump, and that block expired on March 31st. Those are visas like guest worker visas, people who are coming sort of temporarily to the US for one reason or another. And then recently, Biden said that he will be offering 22,000 extra guest worker visas this year, and setting aside 6,000 of those for Central America, well, specifically the Northern Triangle, with the idea that we need to create pathways for people to come to the US legally that may not fit within the the asylum framework or one of the other frameworks that we have currently. Also good news on the citizenship front. Biden immediately issued an executive order recognizing that the Constitution requires that we count in our census the whole person of the state, that we can't discriminate based on immigration status. So that issue is pretty much solved. Then also on February 22nd, Biden announced that we're going to be moving back to the original, I should rather say the 2008 version of the citizenship test. So the administration had basically determined that Trump's updated test, which had more questions, the questions had become a little bit more politicized, that basically increased barriers to naturalization. So we're not going to be using that test anymore. We're going back to what we had before. On temporary protected status, well, actually, this is probably not the best title for this. On temporary forms of status for situations of danger, let's just put it that way. One of which is TPS, temporary protected status. The other which is DED, and that's deferred enforced departure. This is moving in some respects in a good direction, and in some respects in so-so. So First, the Supreme Court just recently heard oral arguments in the case of Sanchez versus Wolf. And this is a case that asks whether TPS qualifies, so when somebody who's been granted temporary protected status, whether that qualifies as being inspected and admitted under the Immigration and Nationality Act. Because this is a super important case, because if someone is inspected and admitted, then they don't have to leave the country in consular process to get an immigrant visa. Okay, so what does that mean? That means somebody can apply to get their green card still being in the US. Okay, because often when people leave, they're by the fact of leaving, they're going to trigger one of the bars, you know, like a 5-year bar, 10-year bar, a permanent bar that won't allow them to come back and be with their family. So effectively, they can't adjust status and become a lawful permanent resident. This case is there's a couple points on this. Number one, during oral arguments, some of the judges appeared very skeptical of whether or not TPS qualifies as being inspected and admitted. So that, you know, that's not great. Second, the administration continued to take this Trump era position that TPS doesn't qualify you to adjust status and get your green card here in the US. So there's, you know, this is that example I mentioned earlier of where the administration could have decided, right? And in theory, they still could, the case hasn't been decided yet, that their legal interpretation is going to be in support of allowing people to get green cards and stay here with their families. But we're not there. So there is a circuit split. The 6th Circuit and the 9th Circuit have said TPS is an admission. The 11th Circuit and then the 3rd Circuit, where it's Sanchez v. Wolf comes out of, said no. And then just 2 months ago in February, our circuit, the 5th Circuit, agreed with the 3rd and the 11th that TPS is not a admission. So that's where we're at with that. And then on the good front, we've President Biden issued deferred enforced departure for Liberians. So this is very similar to TPS. It's a temporary form of protection for folks, and it's designated by the president. Temporary protected status goes to the Department of State. So it's just a little bit of a different process, different section of the law. On January 29th, Biden announced the redesignation of TPS for Syria. Now, this isn't renewing TPS. This is an important distinction that I think sometimes gets missed when you read news articles. So you have, when TPS gets designated, that means everyone before that date can get status for up to 18 months. If TPS is just renewed, that means people in that status can just reapply. So we have TPS for, you know, El Salvador, Honduras, but from like 20 years ago. So those people may still be able to reapply, but nobody new is going to be able to apply. So for the first time since 2016, we had a new designation for TPS for Syria. And then we had a new designation for Venezuela and one for Burma. So that's positive. There are advocates, a lot of folks are calling for a designation for Haiti based on the political situation there. So TPS is, you know, if there's a sort of widespread political situation, a natural disaster like a hurricane, that basically would make it hard for the people in the US to return to their countries and to get, you know, integrated back into society on a, you know, on that, during that time period. And it does come with work authorization. So TPS is let me just mention this. TPS is a very good tool in our, you know, our legal toolbox as a country, but it still is not going to protect everybody, right? So there's people who are not going to qualify under our restrictive asylum definition and who are not going to be able to fall under TPS because they're not from one of those countries that's been designated or they came after that designation date. And so we will probably be hosting another conversation down the road about what Congress can do to make our system more fair. And that's one of the things, is to find another form of complementary protection that would help fill the gaps in our system. So public charge, last slide, folks. Thank you so much for your attention today. I know it's been a lot to listen to. So public charge, February 2nd, Biden basically said, well, we have to review this definition. So public charge has always been something that prohibited people from getting green cards, but the Trump administration expanded the definition so that more things that people do would make them count as public charges and prevent them from getting their green card. So basically, Biden said, let's look at this. And he also asked that the administration look at all the policies, regulations, and practices that create barriers in our legal immigration system. So, hopefully we'll see some good things come out of that. And then on March 9th, the Seventh Circuit lifted the stay that had placed on the district court's order. And so the district court's order vacating the public charge final rule then went into effect nationwide. DHS said, okay, we'll go ahead, we'll move, we'll vacate and change all the language we have from that old rule and, go back to the original definition of public charge. And it's actually announced the administration is not going to continue litigating any of these cases, right? So, that's an example where the administration really was very clear and strong and said, yes, we don't agree with this definition, and we're going to do everything that we can to get us back to the previous status quo. Obviously, one of the biggest things that's been an issue is just the general tone and conversation around immigration over the last several years. And, we've started to see some change, right? And some change in very concrete ways. So on February 16th, USCIS directed all officers to stop using the term illegal alien, to instead say non-citizen or undocumented non-citizen, and then instead of using assimilation, use the word integration. So the language is getting to be a little bit more humane. The other issue that I wanted to just bring to your attention is that the wait time for processing immigration petitions had increased by 46% under the Trump administration. It's really too early to tell if we're going to be able to fix that, this year. But hopefully, the administration is looking seriously at hiring folks and speeding up these processes and in ways that we can do so, and still obviously provide a complete and thorough review of the cases. And then a couple pieces of legislation that consider you to look at supporting that have passed the House and are now with the Senate. So we are moving, I think, in some ways in a very positive direction. There's obviously a lot more we can do. And if you're not on a newsletter and want to get our monthly updates, we try to sort of summarize all the news for folks so you can have like a digest of some of the major things that have been happening. But with that, I am going to
thank you for listening today, and please tune in to our podcast this week.
Okay.
Thank you for listening.
Sorry, it has a voiceover recording. But all of our information can also be found on our website. You can, like I said, email me if you want to sign up for a newsletter. And if you want to find out more about our work or our volunteer or other job opportunities, all that's available on our website as well, with them and our contact information, etc. So I think we are about at time. My phone says we have one more minute. I can stay a few minutes later if folks have questions that are on the call right now that would like to ask questions.
Thanks very much for doing this, Sarah. It's really very interesting.
Yeah, thank you all for coming. Like I said, I know it's been a lot to go through, and hopefully folks learned a few things and can get engaged in your communities and keep us plugging down the yellow brick road in the right direction.
Okay.
Thank you very much from Hillsboro, Oregon. You did a great job. Thank you.
Yeah, thanks for tuning in.
And we got a thank you in the chat as well from Jane. You'll be able to read the chat afterwards. Okay. Jason has his hand up, or no, he's clapping. Okay, that's, I can never type, keep getting that one wrong. Okay, great.
I don't know with matter of MS. Yeah, I think that was what, 2018? Or was that 2019? It's been a couple years now. Yeah, I think that had been stopped in litigation, and then I just don't think it really moved forward. I mean, I haven't heard anything about that. In practice, we never really saw that be an issue, but it obviously was a huge concern. So for those of you who aren't familiar with matter of MS, basically, there's 3 ways people come into the US, right? One is you come in with some kind of visa. We don't typically do much with those cases, but sometimes, folks lose their status and then they end up in immigration detention. Number 2, people present themselves at a port of entry. So that's typically for us, the bridge, but it could be an airport. And 3, they enter without inspection, what we call EWI. And EWI is basically allows people to have a bond hearing with a judge. So if ICE denies, or if ICE just refuses to make a decision, which does happen too, they can go before a judge for judicial review of their custody. And matter of MS was basically saying, no, if you've entered without inspection, you don't have the right to judicial review of your case. You're just going to be totally dependent on what ICE says. And obviously, being an attorney, I'm always for judicial review of pretty much everything, right? I think we need those checks and balances. We're all humans. We make mistakes. Every agency at some point or other is going to make mistakes. Nothing's ever going to be perfect. So what we've actually called for at the Migrant Center is an expansion of hearings to people who arrive at port of entries, because I know this isn't going to make any sense, because it doesn't. But if you present yourself at a port of entry and you say, I'm here at the bridge, I want asylum, you don't have the right to a bond hearing with the judge. All right. So the people who in theory, right, are doing more the legally correct thing and coming to the bridge, which I would just note that, like, the way people come to the US is really based on like what the smugglers tell them to do and how they know to come. And of course, nobody's coming to the bridge right now because we're not letting anyone in. So, that aside, but people who cross without documents can have a bond hearing. People who present themselves at the bridge cannot have a bond hearing, right? So people don't realize this when they're crossing, but if they did, we're really not creating the right incentive here. And so we've called for, and I think this is actually something we could do another like community advocacy letter on, because we don't have one right now, that I think we might have one for Congress, actually. Let me check on that. But yeah, the idea would be to expand the right to a bond hearing. So not just stay with status quo and sort of ignore matter of MS, but really expand that. And create bond hearings availability for everyone. So the other thing that comes up is mandatory detention, which means, folks can't get bond hearings if they fall under certain categories. The issue there is similar to like mandatory minimum sentences. It doesn't really allow for certain like mitigating factors. And that's a congressional, piece of legislation that multiple folks have called to end. We have as well. But yeah, I guess that's really the 2 main problems. The other thing with bond hearings where people aren't getting judicial review is if they've had prior entries. So, we had someone who maybe entered in like 2004. They were, they're 18 and they wanted a job and they stayed for a year or 2 and then they left and they lived in their home country for another 10 years. And then they got into some, political persecution problems, fled, and now they can't get out of detention because of that prior time coming to the US, basically, and being removed prior. So there's a couple of issues with like getting just basically good review of your custody status, and then of course with being able to get released. But yeah, I don't know. I think Lee Turan was on the call. I don't know if Lee, if you've heard anything about matter of MS, or anyone else on the call, but I certainly don't think I've heard anything, at least in the last year. And I know it had been put on hold. I'm assuming that was by a district court. And then I don't know if the administration appealed that or not. I would assume they would have. But then you would think there'd be a decision by now. So yeah, it's a really good question. And if you want to email me, I can try to dig a little bit more and pull up, see if I can pull up any case information. Jim, you're on mute, but I think we're about at time here. So if
We're at
folks have other
time.
questions, go ahead and just email, and I'll try to get back to you.
Okay.
Good night, everyone.
All right. Bill, can you hear now? I've changed when I'm dealing with my email. So if you